SCOTUS may end key protection for minority voters, the looming threat to fair representation. Imagine a world where every vote truly counts, where every voice is heard, regardless of race or ethnicity. Yet right now, the U.S. Supreme Court is teetering on the brink of a decision that could fundamentally change the landscape of voting rights in America. At stake is the future of minority representation, and the SCOTUS order regarding Louisiana's redistricting battle could be the catalyst for a seismic shift in how we protect minority voting power. The Supreme Court has ordered new legal briefings on whether the intentional creation of a second majority black congressional district aimed at complying with the Voting Rights Act might actually violate the U.S. Constitution. This move suggests that the court's conservative majority might be gearing up to deliver a sweeping ruling that could render unconstitutional the very practice of creating districts where minority voters can elect representatives of their choice as stipulated by Section 2 of the Voting Rights Act. But here's where it gets controversial. If the court rejects the idea that the Voting Rights Act serves a compelling interest, it could become increasingly challenging to protect the voting power of minorities. The court's move comes on the heels of a federal court striking down Louisiana's remedial congressional map, arguing it was an unconstitutional racial gerrymander, despite being passed to rectify a prior Voting Rights Act violation. In Louisiana, where black residents make up nearly one-third of the population, the creation of a second black majority district was widely seen as a bare minimum for fair representation. Previously, black residents could only elect candidates of their choice in just one of 6 congressional districts. This is the part most people miss. Previously, the Supreme Court had allowed states some breathing room to consider race when drafting districts to comply with Section 2 of the Voting Rights Act, as long as race was not the predominant factor. But now, the court's order raises the question: what happens when the very practice of creating districts to protect minority representation is deemed unconstitutional? And this is the part that sparks differing opinions. If the court moves forward with such a ruling, it could set a precedent that challenges the very foundation of our democracy. So what do you think? Is this a necessary step to ensure fairness in our electoral system, or a dangerous precedent that could undermine minority representation? Let's hear your thoughts in the comments. In a world where every vote counts, the stakes couldn't be higher. The Supreme Court's decision could have far-reaching implications, not just for Louisiana, but for the entire country. As we await the court's ruling, one thing is clear: the conversation about voting rights and minority representation is far from over. Join the discussion and let your voice be heard. Supreme Court to decide: is racial redistricting in Louisiana unconstitutional? Breaking: the Supreme Court is gearing up to decide whether using race as the main factor in drawing congressional districts crosses the line of constitutionality, and this ruling could reshape American democracy. Here's the scoop. In a surprise late Friday order, the High Court asked both sides in a Louisiana redistricting dispute to explain whether creating a second majority black congressional district violates the 14th Amendment's Equal Protection Clause or the 15th Amendment's voting rights guarantee. But here's where it gets controversial. Some justices worry that mandating more majority-minority districts forces legislatures to prioritize race over traditional districting criteria, potentially running afoul of the Constitution. Background you need to know: after the 2020 census, Louisiana's Republican-led legislature redrew its congressional map, just like every state does, to reflect population shifts. They approved a plan that produced 2 districts in which black voters make up more than 50% of the electorate. A 3-judge federal panel struck down that map in 2022, siding with a group of non-African American voters who argued it was an unconstitutional racial gerrymander. The lower court agreed that race had become the predominant factor, overshadowing standard considerations like compactness, community interests, and geographic cohesion. Originally argued during the 2024 term, the case was quietly set aside for additional briefing and re-argument. The Supreme Court's order keeps Louisiana's disputed map intact for now, but demands detailed legal briefs by August 27th from the appellants, with reply briefs due October 3rd, just before the new term begins. In a rare dissent, Justice Clarence Thomas insisted the court should have decided the case outright instead of calling for more debate. Why it matters beyond Louisiana. This is not just a one-state squabble. If the court rules that creating or expanding majority-minority districts under the Voting Rights Act is unconstitutional, it could severely limit efforts by other states to ensure fair minority representation. On the flip side, critics accuse the Voting Rights Act of encouraging race-based districting, that some view as a form of reverse discrimination, and understanding the legal tightrope. Under the 15th Amendment, Congress can't deny or abridge the right to vote based on race. Meanwhile, the 14th Amendment prohibits unequal treatment under the law. Lawmakers must balance those protections without making race the only or dominant redistricting criterion. To put it simply, they must avoid packing or cracking minority voters purely for political advantage. Think of packing as overflowing a district with minority voters so surrounding districts become whiter, and cracking as splitting a cohesive minority community across multiple districts to dilute its voting power. Political stakes are sky high. Republicans hold a razor-thin majority in the U.S. House, and a ruling against majority-minority districts could boost their prospects in the 2026 midterms. Conversely, limiting such districts might leave minority communities with fewer seats where they can elect their preferred candidates. Bold question for you. Is it fair to prioritize race to protect minority voting strength, or should we stick strictly to non-racial factors like geography and shared interests? And this is the part most people miss. Both sides claim to champion democracy. Which vision wins out? Strict colorblindness or targeted protections under the Voting Rights Act? We want to hear from you. Do you agree that the court should curb race-based redistricting, or do you believe these majority-minority districts are vital for fair representation? Drop your thoughts below and spark the debate. Supreme Court to rule on race-based voting districts. What's at stake? Democracy on the brink. Supreme Court poised to reshape voting representation. In a move that could dramatically alter the landscape of electoral politics, the United States Supreme Court is preparing to dive into a potentially explosive legal battle that could fundamentally transform how voting districts are drawn across the nation. Buckle up for a constitutional showdown that could rewrite the rules of representation. The highest court in the land has signaled its intention to scrutinize the long-standing practice of creating voting districts with racial demographics as a primary consideration. But here's where it gets controversial. This isn't just a legal technicality. It's a potential seismic shift in how minority communities are represented in American democracy. On a pivotal Friday, the Supreme Court justices expanded the scope of an ongoing Louisiana case, setting the stage for a groundbreaking examination of the 1965 Voting Rights Act. The core question at hand: has the landmark civil rights legislation outlived its original purpose? Are race-conscious district mapping strategies still a necessary tool for ensuring fair representation, or have they become a potential obstacle to true electoral equality? The case challenges the long-standing practice of intentionally creating majority Black or majority Hispanic districts, a strategy historically designed to ensure minority communities have meaningful political representation. Proponents argue these districts are crucial for protecting minority voting power, while critics contend they perpetuate racial segregation in the political process. Imagine the potential ripple effects. Dozens of congressional districts could be fundamentally redrawn, potentially reshaping the political landscape in ways we can barely predict. This isn't just a legal argument. It's a profound conversation about the very nature of representation in a diverse democracy. What does this mean for minority communities? How will this decision impact the delicate balance of political representation? These are the questions that will keep political analysts, civil rights advocates, and everyday citizens on the edge of their seats. As the Supreme Court prepares to hear arguments, one thing is clear: the future of electoral representation hangs in the balance. This isn't just a case about maps. It's a case about the soul of American democracy. We want to hear from you. Do you believe race-based voting districts are still necessary? Or is it time for a new approach to representation? Drop your thoughts in the comments below and join the conversation that could reshape our political future.